Good evening, George Will here. Breaking news tonight that escalates the Sussex divorce into the most contentious royal custody battle in modern history. Meghan Markle has filed formal custody petition in Los Angeles Superior Court seeking sole legal and physical custody of both children Archie and Lilibet, with Harry relegated to supervised visitation rights requiring third-party monitor presence during all parental contact. The petition, filed January 16, 2026, under case number 26 STFL 000189, contains 43 pages of allegations, including claims that Harry suffers from substance abuse issues requiring treatment, that his emotional instability makes him unfit for unsupervised parenting, that he has made threats of self-harm that demonstrate danger to himself and potentially to the children, and that his determination to relocate the children to England against their best interests shows judgment so impaired that he cannot be trusted with custody authority. According to sources with direct knowledge of Harry's response, he has retained one of California's most aggressive family law attorneys and has stated emphatically to friends and family that I will fight this in court, I will expose every lie she is telling, and I will not allow my children to be raised by someone willing to destroy their father to serve her own agenda. What you're about to hear involves custody warfare that will require expert psychological evaluations, investigation into substance abuse allegations, examination of parenting fitness spanning years of documented behavior, and legal proceedings that could extend for months or years while two young children watch their parents savage each other in public court filings. The significance of Meghan seeking sole custody rather than joint custody cannot be overstated for anyone who understands family law and the standards courts apply when evaluating custody petitions. California law presumes that joint custody serves children's best interests absent compelling evidence that one parent poses danger to the children's welfare or cannot cooperate in co-parenting relationship. For Meghan to overcome this presumption and obtain sole custody, she must prove either that Harry is an unfit parent whose involvement would harm the children or that joint custody is impossible due to circumstances making cooperation impractical. The allegations in her petition attempt to establish both grounds through claims about substance abuse and emotional instability that, if proven, would support supervised visitation restrictions, and through documented conflict between the parents that she argues makes joint decision-making unworkable. The custody petition itself, obtained exclusively by our investigative team through court records access, presents prosecutorial case against Harry's parenting capacity and character. The document begins with standard jurisdictional assertions establishing that both children have lived in California continuously since birth, that California courts possess authority to determine custody, and that Meghan has been the children's primary caregiver throughout their lives, while Harry's involvement has been sporadic and limited. These foundational claims set up the argument that Meghan's custody should continue as it has existed rather than disrupting the children's established routine through shared custody arrangements. The petition then presents 5 major categories of allegations supporting Meghan's request for sole custody. First, it alleges that Harry has engaged in excessive alcohol consumption requiring professional intervention, with specific incidents including a dinner party in September 2024, where witnesses observed Harry consume an entire bottle of wine and most of a second bottle over 3 hours, becoming visibly intoxicated and making inappropriate comments. The petition cites another incident in November 2024 where Harry allegedly returned home at 2 a.m. in a condition that household staff described as extremely intoxicated, requiring assistance to navigate stairs and speaking incoherently. A third incident in December 2024 allegedly involved Harry drinking heavily during afternoon hours while the children were present, concerning Meghan sufficiently that she removed the children from the house until Harry had sobered. Second, the petition alleges that Harry has made statements suggesting suicidal ideation and self-harm risk, creating danger both to himself and potentially to children in his unsupervised care. The petition quotes Harry as telling Meghan during an argument in October 2024 that sometimes I think everyone would be better off if I just disappeared, and in another conversation in December 2024 stating, I have considered ending it all because there is no point to any of this. The petition cites these statements as evidence of serious mental health crisis requiring professional treatment before Harry can safely exercise parenting responsibilities. Third, the petition alleges that Harry has demonstrated inability to control his anger and has made threatening statements during conflicts with Meghan. The petition describes an incident in November 2024 where Harry allegedly threw a glass object across the room during an argument, shattering it against a wall near where Meghan was standing. Another incident allegedly involved Harry grabbing Meghan's arm during a dispute about the children's schedule, leaving visible marks that Meghan photographed. The petition characterizes these behaviors as domestic violence requiring protective custody arrangements. Fourth, the petition alleges that Harry's judgment regarding the children's welfare is so impaired that he cannot be trusted with major decisions affecting their education, health care, or residence. The petition cites Harry's emergency motion attempting to prevent Meghan from taking the children to London as example of irrational paranoia, arguing that Meghan's plans involved temporary educational exploration that Harry's overreaction transformed into international custody crisis. The petition argues that Harry's inability to distinguish between appropriate parental planning and kidnapping demonstrates cognitive impairment or emotional dysfunction, disqualifying him from joint legal custody. Fifth, the petition alleges that Harry's family in England, particularly Prince William, has expressed hostile attitudes toward Meghan and the children that create toxic environment if Harry obtained custody rights, allowing him to expose the children to royal family influence. The petition quotes alleged statements from William characterizing Meghan as manipulative and untrustworthy and argues that Harry's relationship with his family creates loyalty conflict where Harry might prioritize royal interests over his children's welfare. Now, before we examine Harry's response to these allegations and analyze the legal standards courts apply when evaluating sole custody requests based on parental unfitness claims, I need you to understand what is at stake in this proceeding. This is not routine divorce custody determination where court simply decides whether children spend equal time with each parent or follow a primary custody schedule with regular visitation. This is warfare where one parent seeks to eliminate the other as meaningful presence in the children's lives, reducing that parent to occasional supervised visits while the custodial parent makes all decisions and controls all aspects of upbringing. If you want to follow every motion filed, every expert evaluation conducted, every piece of evidence presented in this battle that will determine two children's entire childhood experience, you need to subscribe to this channel and hit that notification bell right now, because mainstream media will not cover the evidence systematically or analyze the legal implications with the depth they require. The credibility of Meghan's substance abuse allegations depends entirely on whether she can produce corroborating evidence beyond her own testimony. Allegations of alcohol abuse require concrete proof, including witness testimony from people who observed the drinking, documentation such as photographs or medical records, or expert opinion from counselors or physicians who have evaluated Harry's consumption patterns. The petition references witness observations from household staff and dinner party attendees, suggesting Meghan may have secured declarations from these individuals similar to the staff testimony we examined in previous investigations. However, Harry's response will certainly challenge both the accuracy of these observations and the characterization of normal alcohol consumption as abuse requiring custody restrictions. The legal standard for substance abuse affecting custody requires showing that the consumption creates actual risk to the children, not merely that the parent drinks alcohol. California courts recognize that many parents consume alcohol without impairing their parenting ability, and supervised visitation based on drinking allegations requires evidence that the parent's consumption has directly endangered children or occurred during parenting time in ways that affected the parent's judgment or behavior. If Meghan's allegations describe drinking that occurred when children were not present or when the other parent was available to provide care, courts may view the allegations as irrelevant to custody determination. The suicide ideation allegations present more serious concerns because statements suggesting intent to harm oneself can indicate mental health crisis requiring immediate intervention and potentially affecting parenting capacity. However, these allegations are also easily fabricated or exaggerated, as courts recognize that parties in contentious divorces may attribute meaning to ambiguous statements that the speaker never intended. Harry's attorneys will certainly argue that any statements he made were expressions of frustration or emotional distress rather than genuine suicidal planning, and that Meghan's interpretation represents malicious effort to weaponize his vulnerability. The anger management and domestic violence allegations carry the greatest weight if proven because courts prioritize protecting parents and children from violent behavior. However, these allegations must be supported by credible evidence, including photographs of injuries, medical treatment records, police reports, or witness testimony from people who observed the incidents. The petition's reference to photographs of arm marks suggests Meghan may have documented evidence, though Harry's response will likely argue that any physical contact was accidental or defensive rather than aggressive. The alleged thrown glass incident requires witness corroboration beyond Meghan's own account to be credible. Now we must examine Harry's response to these allegations and his vow to fight for custody rather than accepting the supervised visitation arrangement Meghan proposes. According to sources with direct knowledge of Harry's legal strategy and communications with his support network, Harry has characterized Meghan's petition as completely fabricated attempt to destroy his relationship with his children because she cannot control him through intimidation anymore. These sources report that Harry told Prince William in a phone call immediately after being served with Meghan's petition that she is lying about everything. She knows I have never hurt the children or posed any risk to them, and she is willing to destroy me completely to get what she wants. Harry has retained attorney Laura Wasser, widely considered among the most formidable family law practitioners in California, known for representing high-profile clients including Angelina Jolie, Kim Kardashian, and Johnny Depp in contentious custody and divorce proceedings. Wasser's involvement signals Harry's determination to wage aggressive litigation rather than accepting settlement that would give Meghan the sole custody she seeks. Wasser's typical strategy involves thorough investigation of the opposing party's allegations, aggressive cross-examination of witnesses who support those allegations, presentation of comprehensive counter-evidence showing the client's fitness and pursuit of custody, evaluations by court-appointed experts who provide independent assessment rather than relying on partisan claims. Harry's responsive pleading, expected to be filed within 2 weeks of Meghan's petition, will likely present point-by-point rebuttal of each major allegation category. Regarding substance abuse, Harry will likely admit to consuming alcohol socially, but deny that his drinking constitutes abuse or has ever occurred in ways that affected his parenting. He will challenge the characterization of specific incidents, arguing that Meghan is misrepresenting normal alcohol consumption at social events as evidence of addiction. He may present evidence of his own, including testimony from friends and family who have observed his drinking patterns and consider them moderate and appropriate. Regarding mental health and suicide ideation, Harry will likely acknowledge that he has experienced depression and emotional distress, particularly during the marriage breakdown period, but will deny making any statements indicating genuine intent to harm himself. He will argue that Meghan is weaponizing his honest acknowledgement of emotional struggles that many people experience during divorce, attempting to transform normal human vulnerability into evidence of parental unfitness. He may present evidence that he has engaged in therapy and counseling, showing he has addressed his mental health proactively rather than allowing it to impair his functioning. Regarding anger management and domestic violence, Harry will likely deny completely the allegations of throwing objects or grabbing Meghan in ways that caused injury. He will challenge the authenticity or interpretation of any photographs Meghan presents, potentially arguing that any marks visible in images resulted from accidents or Meghan's own actions rather than his aggression. He will present evidence of Meghan's own behavior, including incidents where she directed verbal abuse at staff or engaged in hostile conduct that demonstrates she is not the peaceful victim her petition portrays. Regarding parenting judgment, Harry will argue that his emergency motion seeking to prevent Meghan from taking children to London demonstrates appropriate protective parenting rather than impaired judgment, given the substantial evidence we have examined in previous investigations, suggesting Meghan was planning permanent relocation rather than temporary visit. He will present evidence of his active involvement in the children's lives, including participation in school activities, medical appointments, and daily care routines, contradicting Meghan's characterization of him as absent or uninvolved parent. Regarding royal family influence, Harry will likely acknowledge that his family has expressed concerns about Meghan's character and behavior, but will argue that these concerns are justified based on Meghan's conduct and that maintaining the children's connection to their royal heritage serves their best interests rather than harming them. He may present statements from King Charles or Prince William affirming their commitment to the children's welfare and their desire to maintain meaningful relationships with their grandchildren or niece and nephew. The legal framework governing sole custody determinations in California establishes high burden for the parent seeking to eliminate the other from joint custody arrangements. California Family Code Section 3020 declares that the state's public policy is to assure children frequent and continuing contact with both parents after separation, and to encourage parents to share the rights and responsibilities of child rearing. Courts can deviate from this policy only when evidence demonstrates that joint custody would be detrimental to the children. The standard for determining detriment requires showing that the proposed custody arrangement would cause actual harm to the children's physical or emotional welfare, not merely that it would be less than ideal or that conflict exists between the parents. Substance abuse alone does not establish detriment unless the abuse has directly affected the children or the parent's ability to care for them safely. Mental health issues alone do not establish detriment unless they impair the parent's capacity to provide appropriate care and supervision. Domestic violence between parents can establish detriment if it exposes children to traumatic experiences or if it demonstrates the offending parent's inability to control impulses in ways that could endanger children. The burden of proving detriment rests on the parent seeking sole custody, in this case, Meghan. She must present evidence sufficient to convince the court by preponderance of the evidence standard, meaning more likely true than not true, that Harry's unfitness or the impossibility of co-parenting makes sole custody necessary to protect the children. If Meghan's evidence consists primarily of her own testimony unsupported by corroboration from neutral witnesses or documentary proof, courts typically reject sole custody requests because self-interested testimony is viewed as unreliable in contentious proceedings where parties have strong motivation to exaggerate or fabricate. The custody evaluation process that will likely be ordered in this case involves court-appointed forensic psychologists conducting comprehensive assessment of both parents, the children, and the family dynamics. The evaluator will interview each parent extensively, review all documents and evidence both parties present, interview collateral witnesses, including household staff and family members, conduct psychological testing of the parents to assess personality characteristics and mental health, observe each parent interacting with the children in natural settings, and interview the children themselves at age-appropriate level to understand their relationships with each parent and their preferences regarding custody arrangements. The resulting evaluation report, typically 100 to 200 pages, including appendices and test results, provides the court with expert opinion about each parent's strengths and weaknesses, the children's needs and attachments, and the custody arrangement that would best serve the children's welfare. Courts rely heavily on these evaluations because the neutral expert has access to evidence and observations that exceeds what can be presented through partisan testimony at trial, and because the expert's professional training allows interpretation of behavior patterns and psychological factors that non-expert judges might miss. Now we must examine the systematic pattern of custody strategy that Meghan's petition represents when viewed alongside her other actions, including the New York apartment search, the alleged London relocation planning, and her friendship with Jessica Mulroney, where she discussed divorce timing and tactics. This is not sudden response to Harry's unfitness, but rather implementation of long-established plan to obtain complete control over the children while marginalizing Harry to irrelevance. The timeline of Meghan's custody maneuvering begins with her statement to Mulroney in October 2023 that she intended to seek primary custody and relocate with the children, according to the sworn declaration we examined in previous investigation. From that point forward, every action Meghan has taken can be understood as building the case for sole custody. The separate bedrooms and coordinated public appearances maintained the facade of marriage, while Meghan positioned herself as the stable primary caregiver and Harry as the distant, disconnected parent. The New York apartment search and London real estate inquiries explored relocation options that would maximize distance between Harry and the children while Meghan controlled their daily lives. The passport applications and airline ticket bookings attempted to create facts on the ground where the children were already in Meghan's exclusive physical custody before Harry could contest the arrangement. Now, with the formal custody petition, Meghan deploys allegations designed to support supervised visitation restrictions that would effectively end Harry's meaningful parenting role. If the court credits her substance abuse claims, Harry faces requirements to complete treatment programs and demonstrate sobriety through regular testing before unsupervised contact. If the court credits her mental health claims, Harry faces requirements to complete psychological evaluation and therapy showing stability before unsupervised contact. If the court credits her domestic violence claims, Harry faces mandatory supervised visitation until he completes anger management programs and demonstrates no ongoing danger. Each of these restrictions transforms Harry from equal parent to problem requiring management, while Meghan controls decisions in daily life with minimal interference. The allegation that Harry's family constitutes toxic influence represents a particularly strategic element because it creates justification for geographic distance. If Meghan can convince the court that exposing children to Prince William or King Charles would harm them emotionally, she establishes basis for preventing Harry from taking them to England or allowing royal family visitation. This geographic restriction ensures that even if Harry avoids supervised visitation requirements, his contact with children occurs only in California under circumstances Meghan can monitor and control. The legal and practical consequences of this custody battle extend far beyond the immediate question of where children will live and how time will be divided. The public nature of the allegations means that regardless of ultimate custody determination, both parents and the children suffer reputational and emotional damage that cannot be repaired. Harry now faces public record alleging he is substance abuser, mentally unstable, violent, and unfit parent, allegations that will be indexed by search engines and accessible to anyone researching his name. Even if every allegation is ultimately rejected by the court as false or exaggerated, the mere fact of formal legal claims creates permanent cloud that affects how he is perceived professionally and personally. The children face different damage, the knowledge that their parents made terrible public accusations against each other in proceedings that court transcripts and media coverage will preserve forever. As Archie and Lilibet grow older and inevitably learn about the custody battle, they will read that their mother claimed their father was a dangerous addict and that their father called their mother a liar willing to destroy him for strategic advantage. This knowledge affects children's relationship with both parents and their understanding of marriage, family, and conflict resolution in ways that developmental psychologists recognize as harmful. The royal family consequences flow from the international attention focused on allegations that Prince Harry is an unfit father suffering from substance abuse and mental illness. The monarchy that survived Princess Diana's death, Prince Andrew's scandals, and Harry's own naked photographs now confronts accusations that one of the king's sons cannot safely parent his own children. Whether the allegations are true or false, they damage institutional reputation and create public relations crisis that palace communication staff must manage while maintaining official neutrality about what remains legally a private family matter. Now we turn to scenario analysis, examining the possible pathways this custody battle could follow and evaluating the probability of each outcome based on the evidence, the legal standards, and the strategic positions both parties occupy. Scenario 1 involves the court granting Meghan's request for sole custody with Harry receiving only supervised visitation. In this pathway, the custody evaluation and evidence presentation convince the judge that Meghan's allegations about substance abuse, mental health, and domestic violence are accurate, that Harry poses risk to the children sufficient to justify eliminating his joint custody rights, and the supervised visitation represents the only safe arrangement pending successful completion of treatment programs. This scenario gives Meghan the complete control she seeks and reduces Harry to peripheral figure in his children's lives, seeing them only during scheduled visits with third-party monitor present. However, this scenario requires Meghan to prove allegations that appear designed to maximize damage rather than accurately describe reality, and courts generally resist sole custody determinations absent compelling evidence of genuine danger. Scenario 2 involves the court rejecting Meghan's sole custody request and ordering joint legal and physical custody with relatively equal time sharing. In this pathway, the custody evaluation and evidence presentation reveal that Meghan's allegations are exaggerated or fabricated, that Harry is a fit and involved parent, and that both parents can provide appropriate care despite their personal conflicts. The court determines that the children's best interests require maintaining strong relationships with both parents and that concerns about co-parenting cooperation can be addressed through structured communication protocols and parenting coordinators, rather than eliminating one parent's custody rights. This scenario represents the outcome Harry seeks and the presumption California law establishes, but requires Harry to successfully rebut Meghan's serious allegations through evidence and expert testimony. Scenario 3 involves an intermediate outcome where Meghan receives primary physical custody with Harry receiving substantial visitation rights and both parents sharing legal custody requiring joint decisions on major issues. In this pathway, the court determines that some of Meghan's concerns have merit but do not justify eliminating Harry's parental role, that the children would benefit from stability of primary residence with Meghan while maintaining significant contact with Harry, and that joint legal custody ensures both parents remain meaningfully involved in education, healthcare, and other major decisions. This compromise approach acknowledges the evidence both parties present while avoiding the extreme outcomes, either sole custody or exactly equal time sharing. Scenario 4 involves settlement negotiations where both parties compromise on custody arrangements to avoid extended litigation and expert evaluation. In this pathway, Meghan recognizes that her allegations may not withstand scrutiny and custody evaluation and that attempting to prove them will require depositions and cross-examination that expose her to credibility challenges. While Harry recognizes that even successfully defending against the allegations will cost enormous sums in legal fees and will require months or years of proceedings. The parties negotiate schedule, giving Meghan slightly more time as primary parent, but ensuring Harry receives substantial regular contact, with both sharing legal custody and neither subject to supervised visitation requirements. This scenario provides both parties certainty and allows them to move forward without the emotional and financial devastation that trial would produce. Scenario 5 involves Harry obtaining primary custody based on evidence that Meghan's willingness to make false allegations demonstrates her unfitness. In this pathway, the custody evaluation reveals that Meghan fabricated or grossly exaggerated her claims about substance abuse, mental health, and domestic violence, that her willingness to employ such tactics shows prioritization of her own interests over the children's welfare, and that Harry is the more appropriate custodial parent because he has demonstrated ability to support the children's relationship with both parents rather than attempting to destroy the other parent through litigation. This scenario represents the most dramatic reversal of Meghan's petition, but would require Harry to present overwhelming evidence of Meghan's dishonesty and alienating behavior. Based on everything we have examined, the serious nature of Meghan's allegations requiring substantial proof to support, the high burden California law establishes for sole custody determinations, the likely appointment of custody evaluator who will provide independent assessment, and the strategic incentives both parties face to settle rather than endure protracted litigation, Scenario 3 or Scenario 4 appears most probable. The court will likely determine that both parents should maintain significant roles in the children's lives, with Meghan possibly receiving slightly more time as primary caregiver, but Harry retaining meaningful custody rights and neither parent subject to supervised visitation, absent truly convincing evidence of danger. The next developments will occur as both parties begin discovery, seek custody evaluation, and prepare for hearings on temporary custody pending final determination. Within 2 weeks, Harry's response to Meghan's petition will be filed, presenting his counter-allegations and requesting joint custody. Within 30 days, both parties will submit requests for custody evaluation, and the court will appoint evaluator and establish timeline for assessment. Within 60 days, the evaluator will begin interviews with both parents, household staff, and other collateral witnesses. Within 90 days, psychological testing will be completed and home visits will be conducted. Within 120 to 150 days, the evaluation report will be completed and submitted to the court and the parties. If you want to know what the custody evaluation reveals, what evidence both parties present to support their competing fitness claims, what the expert recommends regarding the appropriate custody arrangement, what temporary schedule the court orders while final determination is pending, you need to subscribe and hit that notification bell right now. Type sole if you think Meghan's allegations justify sole custody to protect the children. Type joint if you think both parents should share custody equally despite their conflicts, or type primary if you think Meghan should have primary custody with Harry receiving substantial visitation but not equal time. Because what we have covered tonight is just the opening salvo in a custody battle that will determine whether two children grow up with meaningful relationships with both parents or whether one parent succeeds in marginalizing the other to irrelevance. The real question is whether Meghan can prove her explosive allegations or whether Harry can expose them as strategic fabrications, and that answer will determine the entire trajectory of these children's lives. I am George Will, and I will see you in the next investigation.